News.
These cases began as an investigation into family child sex abuse. Law enforcement sought the DNA of Gary Ciders Jr. related to the child sex abuse case. Once Ciders Jr. was located, search warrants were executed to secure his DNA for genetic testing. Upon serving the search warrants for the child sex abuse case, the existence and condition of the 16 children at the
These cases began as an investigation into family child sex abuse. That is the official record, one sentence delivered without inflection by a county prosecutor, but the sentence does something strange. It tells you what was being investigated, then quietly admits that what was found was never the original target. Now read the fuller statement. Law enforcement wanted DNA. To get DNA, they needed a warrant. To serve that warrant, they went to a house. And in that house, they found 16 children. The document does not say rescue, it says, became known.
Omar Street house became known. The child sex abuse cases involve intra-family relations and do not pose a risk to the general public, and I would also add, does not involve human trafficking. This case all started with diligent Dollar General clerks.
That phrases the whole scandal in miniature. Not 16 children were saved. Not 16 children were removed. 16 children became known. As if they had been there the entire time, waiting for someone to look. Picture a manila evidence folder sitting on the passenger seat of a patrol car. The folder is closed, but the tab is labeled DNA warrant. The officer doesn't open it again. He doesn't need to. Because the house in front of him was already answering a question no one had asked out loud yet. That image is not from the filing, it is what the filing implies.
Calling authorities with concerns over children they observed. We ask the public to be mindful of the circumstances around.
Before we go deeper into what the documents actually show, make sure you're subscribed to Trial&Crime, because we don't just cover the story, we follow the evidence. And the evidence here begins with a timeline that should not work, but does.
A Benton County grand jury today has issued indictments in 3 criminal cases involving sexual abuse and child endangerment. These charges stem from criminal investigations conducted by the Benton County Sheriff's Office and the Ohio Bureau of Criminal Investigations, BCI. The cases are being prosecuted by the Benton County Prosecutor's Office with the assistance from the Highland County Prosecutor's Office and the Ohio Attorney General's Special Prosecutions.
December 2025, the Ohio Bureau of Criminal Investigation opens a case involving 2 children. March 2026, that case produces information that opens a second case. June 30th, a search warrant takes investigators to Omar Street in Hampton, Ohio. The gap between March and June is just over 3 months. That is not a long time in bureaucratic terms. Yet by the time a warrant is executed, the house contains 16 children. 16, not 2. The math is not complicated. The math is damning.
Unit. In December of 2025, at the request of the Benton County Sheriff's Office, BCI's Special Victims Unit opened an investigation into allegations of sexual abuse involving 2 children.
Now read the indictment language closely. Gary Cider Jr. and Elizabeth Cider are charged with 4 felonies each. 2 counts of sexual battery, 2 counts of unlawful sexual conduct with a minor. The alleged conduct runs from January to September 2022. The victim is described as more than 10 years younger than the defendants. And then this line, the victim is not a member of their immediate family.
The grand jury has indicted Gary Ciders Jr. and Elizabeth Ciders on 4 felony charges each, 2 counts of sexual battery and 2 counts of unlawful sexual conduct with a minor. I've learned law enforcement.
That single sentence does enormous work. It separates the child sex abuse charges from the child endangerment charges. It tells you the minors named in the sex crime counts are not the 16 children found in the house. And it raises a question the prosecutor later tries to close down. If the victims are not immediate family, why does he keep calling the case intrafamily? The contradiction is not an accident. It is a crack in the official narrative. And once you see the crack, you cannot unsee it.
Well, that was somewhat telegraphed, as we talked about the other day, by a statement of the prosecutor from Benton County in opposing reduction of bond for Elizabeth. And so we knew something was coming. What seems surprising about this, and it is really unclear as to who the alleged victims are. It looks like the indictment or charges against the 2 Ciders go back to 2020.
The former prosecutor in the room notices it too. He flags that the press release says one thing, while the county prosecutor said something else. He notes that the charges go back to early 2022. He notes that the victims are unnamed, and then he says what any careful reader should feel. It is really unclear as to who the alleged victims are. Unclear. In a case with 16 children in one house. Unclear. That word is not legal analysis. That word is a warning.
Yeah, we're digging into that for sure and clarifying. And I want to read what the press release says. It says the indictment alleges that between January and September 2022, the defendants engaged in sexual conduct with a minor more than 10 years younger than their own age. The victim is not a member of their immediate family. So it said, he said, this says not a member of the immediate family. However, the prosecutor said this was an intra-family thing.
So let us lay out the indictment as it stands. Two separate investigations, one beginning in December 2025, one beginning in March 2026. The second investigation names Gary Jr. and Elizabeth. The first investigation does not. Yet the first investigation allegedly led law enforcement to them. The victims in the first case are not the children in the house, but the victims in the second case are allegedly connected to the defendants in the first. The paperwork already knew.
And at least since the two investigations were tied, the ones for which the indictment on the sex offenses against the Ciders today arose from the investigation of the other two men indicted in the case, it may be that the same victims are involved, and that in the course of the first investigation, the victims relayed that the Ciders also were involved either with the knowledge of the two other men and also indicted today, or whether or not they was a follow-up.
And I've learned that
Here the timeline tightens. The information about Gary Jr. and Elizabeth came from the investigation of two other men, Josh Saunders and Brandon Henderson. That investigation began in December 2025. The former prosecutor says either those men provided information to law enforcement or the victims in that case did. Either way, the path does not start with a Dollar General clerk. It starts with a separate child sex abuse case. And that path dead ends at Omar Street.
Investigation 1, which involves Josh Saunders and Brandon Henderson. This is investigation 1 that it began in December of 2025. The information about Gary Ciders Jr. and Elizabeth Ciders was developed from that investigation. So that is what led the law enforcement officers initially to that house on June 30th. People were saying, oh, it's because they went there for a public indecency warrant for Gary Jr. I think you and I knew the whole time, and I've been saying the whole time, no, they didn't go there with a search warrant for a public indecency case.
For months, the public narrative leaned on a simpler story. Officers went to the house on a minor warrant, maybe a public indecency matter, something small. But the former prosecutor says the opposite. You do not bring the Ohio Attorney General's office to serve a warrant on an exposing case. You bring that office when the warrant is a predicate. When the warrant is the first domino, not the last. That is exactly what the documents now confirm.
This was going to be much more serious.
Yeah, and I think we both kind of concluded that at the time, based on the conduct of the investigators, you don't have the Ohio Attorney General down in Vinton County for a warrant on a exposing case. And it's interesting how that exposing case may tie in with these subsequent charges.
Now consider what would have happened if the DNA warrant had been served in March instead of June, or if the December investigation had stalled, or if the second investigation had been filed separately without cross-referencing names. 16 children would still have been in that house. That is the ticking clock underneath every hearing, every press release, every redacted line. How many more warrants would have missed them? How many more months did the file sit open while the house stayed full?
The only thing I can try and extrapolate from this is either the two men that are charged in the case as well are providing information to the prosecutor and the attorney general that led them to the Ciders, or alternatively, the victims in that case provided information that the two men not only perped on them, but that the Ciders were involved in sexual misconduct with them. Either of those options would tell me is likely as to how they got on the doorstep of the Ciders with the search warrant this summer.
The former prosecutor maps the logical route. Either the two men charged in the first case cooperated, or the victims in that case identified the Cider as additional perpetrators, Both possibilities mean the original investigation was always larger than it looked. Both possibilities mean the house on Omar Street was not a random discovery. It was an intersection. One file crossing another, one case spilling into the next. The paperwork already knew.
And, we still have pieces of this puzzle that we are assembling. One thing that really piqued my interest was that William Archer, the Vinton County prosecutor, said that alert Dollar General employees contacted law enforcement about their concerns about some of the children that they saw with Gary Jr. and Elizabeth Ciders. They were very concerned. And so it seems like potentially we may have had a couple of different things going on here. We have Dollar General employees, and then we also have this investigation one where information.
Then comes the part the prosecutor wants credit for, the so-called diligent Dollar General clerks. He says the case all started with them, but the timeline says otherwise. The December investigation started with 2 children. The March investigation started with information from that case. The June search warrant started with DNA. The Dollar General clerks may have called, but the case was already moving. The credit he gives them is chronological sleight of hand.
Is gathered and gleaned about the couple, and all of that was enough to potentially get this search warrant for the house on June 30th.
Yes, and at least it's probably the addition of all that kind of information, potentially from co-defendants, victims on the first case, and the children may have said something at the Dollar General to an employee there that piqued their interest and passed it on to law enforcement. And then they were already looking into the matters the other 2 men and the Ciders had been involved in going back. That's 4 years.
The clerks themselves are silent now. When asked, they will not speak. The prosecutor suggests law enforcement told them not to. That is plausible. It is also convenient, because if the clerks speak, they might correct the record. They might say they saw something specific, something the official timeline does not want to emphasize. The indictment is precise about dates and charges. It is silent about what the clerks actually saw.
And that well could be the case, and the law enforcement personnel would have told them not to talk to anybody such as yourself or others.
These allegations involving Gary Jr. and Elizabeth, as you stated, go back years. But as we know, things like this, it doesn't seem like it's usually a one and done. So the sheriff said that this investigation is ongoing. And we know from the Vinton County prosecutor telling the commissioners we're seeking permanent custody of the children, that's going to happen. And they will more than likely be successful in obtaining.
What we are left with is a charging document that admits more than it explains. Gary Jr. and Elizabeth face sex crime charges involving a minor who is not their immediate family. Gary Ster and Christina face child endangerment charges but no sex charges. The 16 children remain in custody proceedings. The sheriff says the investigation is ongoing. The prosecutor says permanent custody is the goal, and the question no one asks is who else is in the file.
Permanent custody of the children, especially if there's a conviction on a sex crime. So I'm thinking to myself, if this investigation is ongoing, is there going to be more there? Are we going to see potentially more indictments?
Well, at least if they thought they had enough on inter-family sexual misconduct, I would have included it in the indictment today. And so either they don't have enough because it wasn't going on inside the family home, or the children are still in the process of being interviewed, going through social workers and psychological treatment and testing, and they may not want to proceed at this point. They can always, as you know, produce a superseding indictment.
The former prosecutor raises the possibility of a superseding indictment. That is the legal mechanism for adding charges after the first indictment. It means the current charges are not the ceiling, they are the floor. Children may still be interviewed. Social workers may still be reviewing files. Psychological records may still be pending. The case is not frozen, it is breathing, and every breath can produce a new count.
Ron, let's move on now to the elder Ciders. Gary Ciders Sr. is 73 years old. He's out on a signature bond wearing a GPS bracelet when he was released on that signature bond because of his serious medical issues, the Vinton County prosecutor said, look, he's not a threat to the public. But he and his wife, Christina, the grandparents, have now been indicted. They're facing 2 counts of child endangering felonies in the 2nd degree, 10 counts of endangering children, felonies of the 3rd degree, and then 7 counts of endangering children. Those are misdemeanors. They are not charged with any sex crimes. So how do you see their cases ending up? Because, I mean, they're challenging their competency, or at least their lawyers are saying they may not be competent to stand trial. However, they have not been charged with any sex crimes.
The elder Ciders are a separate problem. He is 73 on a signature bond, wearing a GPS bracelet released because of medical issues. She remains in jail. Neither is charged with a sex crime. Their lawyers are already raising competency. But competency is not innocence. It is a delay mechanism. It tells you the defense is already preparing for a long fight, and it tells you the prosecution has not yet said everything it knows. The paperwork already knew.
And the Ohio Attorney General's Special Prosecutions Unit. In December of 2025, at the request of the Vinton County Sheriff's Office, BCI's Special Victims Unit opened an investigation into allegations of sexual abuse involving 2 children. Information obtained in this investigation prompted BCI in March of 26 to open a second investigation, this one involving allegations of unlawful sexual conduct with a minor. On June 30th, authorities executed a search warrant at a residence in Hampton, Ohio, and Vinton County on Omar Street. There have been a lot of speculation and questions regarding the June 30th presence on Omar Street in Hampton. These indictments provide some insight into the ongoing investigation. However, to preserve the integrity of the ongoing investigation,
The former prosecutor's conclusion is blunt. The elder Ciders face child endangerment charges only. That means either there is no evidence of sex offenses inside the home, or no one has found it yet. Both possibilities are uncomfortable, because if the sex abuse was happening elsewhere, the house was not the whole story. And if it was happening inside the home, the current charges are incomplete.
In jail, they will have to be arraigned now that they have been indicted on these new charges. And remember, you can read the entire Ciders case file on our app. It's called lawandcrimeplus.com. And that's it for this episode of Crime Fix.
Here is what you can do. Go to the Vinton County Clerk of Court's website. Pull the indictment for Gary Cider Jr. and Elizabeth Cider. Look at the charge language. Look at the date range. Then look at the list of witnesses if it is unsealed. Ask yourself one question in the comments. If the victim in the sex crime counts is not immediate family, then who is the minor named in the indictment? That is not speculation. That is a public record. Like, share, subscribe, and turn on notifications for Trial Crime. We will be here when the next filing drops.